Okay, so welcome back. For those who missed the earlier sessions, I'm Joe Newhouse, chair of the ITA. I want to welcome you to the third session of ITA's four-part seminar, Focus on the Draft Code of Conduct for Adjudicators in Investor-State Dispute Settlement. Our first session on Monday addressed issue conflicts and the code's provisions in Article 5, particularly Article 5.2d, calling for potential arbitrators in investor-state disputes to disclose all publications and all relevant speeches. Yesterday, we heard an excellent discussion of double hatting, which is addressed in Article 6 of the draft code. I would say we heard some very different perspectives on the issue. There are advocates of a prohibition on arbitrators in investor-state arbitration also serving as counsel in such arbitrations, with discussion around the scope of such prohibition. And we heard from those who said that such a solution risked limiting the pool of arbitrators to those few who can fill that role as a full-time job, thereby perpetuating the sense of a club and limiting diversity. It was also said that such a prohibition would seriously limit party choice in, for example, cases where there are very few candidates who have experience or expertise that a party may be looking for in an arbitrator. These panelists urged that at least in ad hoc arbitration, disclosure, not prohibitions, were the answer, that is, at least in investor-state arbitrations. Panelists also advanced the point that perception of the issue may be more important than the actual scope of the problem. Or as one panelist put it, perception is reality. And Anna Joubin-Brett concluded with the observation that criticism of ISDS has crystallized, as she put it, around double hatting. And she suggested that the code will need to have a strong answer on this issue. Again, as on Monday, it was a great discussion, and I'm looking forward to more today. For those who missed it, the full panel was recorded and will be publicly posted. We'll send a link to all those who registered for any of the sessions. Today's focus is on repeat appointments by a party or counsel of the same arbitrator. And we'll finish up tomorrow with questions on implementation and enforcement of the draft code. I'm going to hand the podium over now to Chiara Giorgetti and Tom Sikora, our moderators and the organizers of the whole week's events. ITA is proud to have them in our leadership and of the world-class faculty they have gathered for this seminar. So with my thanks, Tom or Chiara.
Thank you very, very much indeed, Joe. Good morning, everyone. Good afternoon. I'm Tom Sikora. I am the Senior Vice Chair of the Institute for Transnational Arbitration, and I have the honor of introducing our distinguished faculty today. I will do so in alphabetical order, and starting with Mr. John Crook. John Crook teaches international arbitration at George Washington University Law School. He is a judge on NATO's administrative tribunal and frequently acts as arbitrator in international investment and other disputes at ICSID, the PCA, and other settings. He was a commissioner on the Eritrea-Ethiopia Claims Commission, which successfully addressed the extensive claims following the two countries' lengthy civil war. John served for nearly 3 decades in the U.S. State Department's Office of Legal Advisor, where he was U.S. agent at the Iran-U.S. Claims Tribunal in The Hague, was deeply involved in creating the UN Compensation Commission in Geneva, and appeared several times before the International Court of Justice. After leaving the State Department, he moved to Rome, where he was General Counsel of the Multinational Force and Observers, which operates a peacekeeping force of soldiers and observers in the Sinai Desert. John has written extensively on dispute settlement, as an honorary member of the American Journal of International Law's Board of Editors. He's a past vice president of the American Society of International Law. Next is Professor Mark Feldman, who's a professor of law at Peking University School of Transnational Law. He also serves as Global Associate at the National University of Singapore Center for International Law, and serves as Vice Chair of the Institute for Transnational Arbitration's Academic Council, and as a member of the ITA Executive Committee. He previously served as a member of the E15 Initiative Task Force on Investment Policy, and chief of the NAFTA-CAFTA DR Arbitration in the Office of Legal Advisor at the U.S. Department of State. As chief, he represented the U.S. as respondent or non-disputing party in more than a dozen investor-state disputes and provided legal counsel supporting the negotiations of U.S. bilateral investment treaties and investment chapters of free trade agreements. His government experience also includes service as a clerk to Judge Eric Clay of the Sixth Circuit U.S. Court of Appeals and as a Peace Corps volunteer in Lesotho. He previously practiced in the private sector for several years at the law firm of Covington & Burling in Washington, D.C. Next comes Meg Kinnear, who's of course the Vice President of the World Bank Group and the Secretary General of the International Center for Settlement of Investment Disputes. Ms. Kinnear was formerly the Senior General Counsel and Director General of the Trade Law Bureau of Canada. In November 2002, Ms. Kinnear was also named Chair of the Negotiating Group on Dispute Settlement for the Free Trade of the Americas Agreement. From 96 to 99, Ms. Kinnear was Executive Assistant to the Deputy Minister of Justice of Canada. Prior to that, she was counsel at the Civil Litigation Section of the Canadian Department of Justice. She's called to the Bar of Ontario, the Bar of the District of Columbia. She received a Bachelor of Arts from Queen's University, Bachelor of Laws from McGill, and a Master of Laws from the University of Virginia. Next, David Probst is an associate expert in international trade law at the UNCITRAL Secretariat, where he services Working Group 3 on Investor-State Dispute Settlement Reform. Before joining UNCITRAL, David worked as a lawyer for an international law firm in Germany, focusing on investment arbitration in the energy sector. David holds an LLM in international law from the Fletcher School of Law and Diplomacy. Professor Victoria Shannon Sahani is the Associate Dean of Faculty Development and a Professor of Law at the Arizona State University's Sandra Day O'Connor College of Law. She's also the Director of the Faculty Inclusion Research for System Transformation Initiative, a university-wide initiative looking at the history of race and inclusion among faculty at the university. Professor Sahani holds several leadership positions in international arbitration community, including Vice Chair of the ITA Academic Council, member of the ICC Commission on Arbitration and ADR, and co-chair of the Academic Subcommittee of the U.S. Council for International Business, USCIB Arbitration Committee. She's the co-author of a book on third-party funding in international arbitration, as well as numerous book chapters, articles, essays, and blog posts. Prior to joining the Legal Academy, Professor Sahani served for 5 years as Deputy Director of Arbitration and ADR in North America for the ICC International Court of Arbitration, as well as Deputy Director of the Arbitration and ADR Committee of USCIB. She earned her undergraduate degree from Harvard University and her law degree from Harvard Law School. So that is our distinguished panel. And with that, let me turn it over to Professor Giorgetti to introduce today's issue.
Thank you very much, and many thanks to Tom and Joe for the introduction. My name is Chiara Giorgetti, and I'm a professor of law at Richmond Law School and the chair of the ITA's Academic Council. While I was on sabbatical last year, I had the opportunity to be a scholar in residence at the ICSID Secretariat and also worked on the draft code, which is an issue which I think is terribly important. As mentioned by Joe, in the first 2 webinars of the series, we discussed issue conflict and double heading. And today we will discuss repeat and multiple appointments. And this is another issue that has raised quite substantial criticism during the ISDS reform process. And indeed, some say that the repeat appointment is really at the origin of the problem with ISDS because there's a small community of people that largely know each other around in the same circle. and that the fact that these people are appointed repeatedly may result in biases that can be conscious or unconscious, but may result in a lack of independence and impartiality, which reflect then in their decision, and they may be then more keen towards espousing either the position of a specific party or more generally of a specific side. So the issue is, if repeat appointment is seen as as problematic, how do you regulate it? And there are many ways to do it. One possibility, of course, is requiring disclosure, more disclosure, so that the parties, counsel all know the situation. And this is the approach, partially the approach that is taken by the draft code. Another possibility is to reduce the number and mandate a specific number of cases in which an adjudicator may sit, or establish a temporal limit of the number of cases also. And of course, ultimately, there's the possibility of the creation of a permanent court, which in fact would be somehow represent an ultimate repeat appointments, because the judges would always be the same, but at the same time will avoid the problem of parties choosing the same adjudicator. And so the problem is, how do you regulate this issue if the issue becomes problematic and has been signaled as a possible problem? On the other side, some say that in fact repeat appointments might be a benefit, because it intrinsically provide more competency, and there's a consistency in the system too. And another problem that is signaled by repeat appointment, that arises from repeat appointment, is the issue of availability, which is addressed by the code also in Article 8. And the issue is, if an adjudicator sits in too many cases and it is impossible for him or her to address all the issues fully and dedicate the right amount of time. Of course, this is another highly subjective issue on how many cases and whether it should be an issue itself. So these are some of the issues that arise when we're thinking about multiple appointments and repeat appointments. And to learn a little more about this, we have asked experts to illuminate and to discuss some of the issues that are linked to repeat appointments. We will start by looking at a general discussion on the issue of repeat appointment, the implication of how to regulate repeat appointments. And first I will invite Matt Kinnear to tell us a little more about the draft code itself, and how the draft code regulates the issue of repeat appointment. Thank you very much.
Thank you very much. Well, it falls to me again this morning to provide some context for this discussion. We do hear a lot of debate about repeat appointment, and I think throughout this discussion, it's vital, once again, to go back to basics. Number one, when does this occur? How often does this occur? Is it really a problem, or how much of a problem is it? And number two, just from a policy perspective, do we think repeat appointment is problematic from an ethical perspective? I'm going to go through and address how the draft code addresses repeat appointment. And you might very understandably suggest to me that the draft code does not address repeat appointment, because clearly there is no express prohibition on repeat appointment, and there is no article specifically dealing with repeat appointment. And I think it's fair to say that we started from the premise that the mere fact that the adjudicator is reappointed in and of itself is not problematic from an ethical perspective. This is consistent with case law to date, which has refused to disqualify arbitrators, again, based solely on the number of appointments they have had. It's consistent with the freedom to appoint one's own arbitrator. And I think in many ways it can be said to be consistent with the policy goals in the reform process to have capable, effective, and arbitrators who are able to deal with their cases expeditiously. And as Chiara has noted, it's almost ironic that one of the other options that's often discussed is the idea of a court, which would be a very set number of people constantly being reappointed, and the virtue seen out of that is being able to create expertise, act expeditiously, and create consistency. So it's interesting to put the two sides together in this respect. That said, there are various parts of the code that, even though they are not labeled repeat appointment, I think could be relevant in terms of a repeat appointment situation. And the big issue here in every case is not is there just repeat appointment, but repeat appointment plus what other facts. And that is really the key, both in current case law as well, I think, as when you're going to apply the code. So the most relevant provisions obviously are the general duties in Articles 3 and Article 4. And essentially they are the general duties to be impartial and independent. And the argument that you hear in this respect proceeds along the line that repeat appointment combined with other circumstances or other facts makes the repeat appointment a breach of the duty to be independent or impartial. And of course, one example is the allegation that the repeat appointment is by the same party, the same counsel, or the same law firm. And indeed, IBA Rule 3.13 has put the fact that an arbitrator has been appointed on 2 or more occasions by one of the parties in the last 3 years as one of their orange list situations. Another example here, I think, which is specific to ISDS and a very difficult one, is the allegation that an arbitrator is consistently appointed or reappointed either by an investor or by a respondent. And the allegation essentially suggests that the arbitrator is pro-state or pro-investor and therefore doesn't come to the problem with an open mind. I think this is highly debated among a lot of people, whether this is even a correct characterization, but it is one that we have heard in the discourse. To date, the few cases that have addressed this argument have held that the mere fact of reappointment by an investor or by a state without any other relevant facts is insufficient to create a conclusion of lack of independence or lack of impartiality. But it's highly likely that delegates are going to have to wrestle with these kinds of situations, and in particular try to address what is that package of additional facts that might push you over the line of acceptable or problematic from an ethical perspective, or is there such a line in this context? Another relevant part of the code is the expanded disclosure requirements. And this, of course, requires the parties to have all relevant information at the beginning of the case. And in particular, the Article 5, Sub 2, Sub C, requiring an arbitrator to provide all of their cases that they've acted in previously is relevant to this obligation and relevant to the question of repeat appointment. You know immediately, has there been repeat appointment? And you should have the necessary facts from day one to be able to either waive that or to ask the arbitrator recuse, or if the arbitrator doesn't recuse and you feel strongly about it, to bring a motion to challenge. The final article that might address or that might be invoked in this kind of situation is Article 8 on availability. And it would come at it not from the perspective of there's something problematic in se or problematic joined with other facts about reappointment, but rather, is there a problem that an arbitrator has been reappointed so many times and has such a large docket of cases that they are unable to give the case the attention it needs and to act expeditiously. And we've heard in the profession various concerns about over busy arbitrators who some parties feel cannot address the case in an expeditious fashion. Article 8 requires an arbitrator to be available and to be able to perform their duties with due diligence. And you will note in particular that Article 8 Sub 2 puts in square brackets the idea of a blanket prohibition on the number of cases that might be taken. So that square brackets indicates obviously that it is preserved for discussion. But I would like to draw your attention to what is noted in the commentary, which frankly is that that kind of a blanket prohibition is probably both under-regulating and over-regulating and really not that effective. An absolute limit on the number of cases completely ignores the capacity of any single arbitrator And there are a lot of considerations as to whether you're going to be able to address a case with due diligence. What's your role? A case normally demands a lot more of a chair than of a wing. How complex is the case? What is the status of the other cases that the arbitrator is holding? If an arbitrator has a lot of other suspended cases, they will likely be able to deal with yours and there won't be an availability question. So those are the few parts of the code which might come into play where you have a repeat arbitrator situation. And I will leave it to my colleagues now to address whether this is a satisfactory way to go at it and whether it fits within the scheme of ISDS adjudication. Thank you.
Many thanks, Meg. This was a wonderful overview about the draft. And as you said, the code addresses several instances of repeat appointment and some on different sides. And state delegates will really have to make decisions, take decisions on what they prefer to include in the code. And so I think it will be quite interesting to hear now. So what are states kind of delegate? What are state delegates looking for? What is the mandate that UNCITRAL got, and what is the background and approach the Working Group 3 uses in terms of the draft code and specifically on the repeat appointments question? David, could I ask you to address these questions?
Thank you very much, Chiara. First of all, I would like to mention that Anna Jobamret, who was supposed to sit in my virtual seat here today, was not able to join. So she sends her regards and sends me as a replacement. And thank you for bearing with me today. I'm happy to give a brief overview of the mandate of Working Group 3 and also the discussion so far of the working group on the issue of repeat appointments. The working group, as many of you know, has a three-phase mandate on the reform of ISDS. First, to identify concerns with regard to ICS. Second, to decide on the desirability of a reform. And third, to develop concrete reform options. In October last year, the Working Group 3 has entered phase 3, which means that we are now trying to match the concerns identified in the first phase with concrete reform options. In the two sessions in 2018, the working group identified concerns with regard to, inter alia, the diversity of arbitrators and with regard to their independence and impartiality. With regard to diversity, it was noted in the working group that in ISDS there is a concentration of arbitrators from a certain region, a limited age group, one gender and limited ethnicity, which was then provided also in empirical data. It was also stated that there was not enough arbitrators who understand the policymaking concerns in developing countries, and that this lack of diversity might negatively impact the correctness of decisions made and the perception regarding the impartiality and independence of the arbitrators. It was said that repeat appointments were closely linked with this lack of diversity. Also, the working group identified repeat appointments as a potential cause of lack or perceived lack of independence and impartiality. For example, it was mentioned that against the background of the current party appointment mechanism, arbitrators are commonly characterized as either state-friendly or investor-friendly, based on their repeated appointment by one or the other party. And this was described as potentially undermining the legitimacy of ISDS. It was then also mentioned that dissenting opinions by the arbitrator appointed by the losing party may contribute to this perception. It was also considered problematic that arbitrators can be appointed by different parties, but for cases with similar circumstances, in particular with similar legal issues involved. The orange list in the IBA rules, which Meg already mentioned, set a fixed limit for the number of appointments. In the working group, however, it was also noted that it's difficult to determine whether a repeat appointment has an impact on the independence of arbitrators or create a bias. And accordingly, it is also difficult to set a limit for the acceptable number of appointments and other criteria, in particular the economic significance of repeat appointments, or of potential overlap of facts or legal issues of the cases involved, may also be considered. And now Article 5 of the draft code provides for a more comprehensive disclosure requirement, which now covers also prior appointments. On this basis, on the basis of the disclosed information, the parties can now make an informed decision on whether to waive a conflict or whether to challenge an arbitrator, which Meg also already mentioned. The decision, however, if the repeat appointment indicates a lack of independence and impartiality, or the perception thereof, is still with the body who is deciding on the challenge. As Meg mentioned, the code as such does not specifically address this decision-making process. Now it's important to see this Article 5 first in the context of the Articles 3 and 4, and also 8.2, as Meg already pointed out. And it is also important to see this article and the discussion on repeat appointments as such in the context of other reform options currently on the agenda of the working group. In particular, the reform options regarding the selection and appointment of arbitrators. In this context, one proposal is to establish a permanent body, which Chiara mentioned in her introduction, where adjudicators would be employed full-time and would not have any outside professional activities. In this reform option or this scenario, disputing parties would have no or very little influence on the selection and appointment of adjudicators, which would also change the parameters of the discussion on repeat appointments. And this is it from me, and back to Chiara. Thank you.
Thank you very much, David. This was very interesting. Give us a little background on what really states asked and what are the different options that exist. Before we continue, I pasted for our attendees, I pasted the link to the code. And I note that the code has both the provisions and the commentary, as Meg also pointed out, which explains a little bit the provisions. So if you'd like to follow our discussions with the text of the code, just press the link. And also, if you have any questions, we hope to have some time at the end of our session for a Q&A, and the Q&A function at the bottom of your screen is open. So please feel free to ask questions. So now we have a little bit of a background now on the code, what the substantive provisions, what the provisions say, where they are coming from. Mark, at one point, really what we say is that repeat appointments really touches many different issues. And I wonder if you can tell us a little more about the core issues that are involved when we're trying to address multiple and repeat appointments.
Sure. Thanks, Chiara and Tom and the ITA for the opportunity today. I'd like to share a few thoughts, Chiara, as you mentioned, on repeat appointments in different contexts. And the three different contexts would be impartiality, independence, and diversity. And I think for now, I will focus on impartiality and independence, and then later in the session, offer a few thoughts on diversity. You had mentioned the commentary that's in the code, and I'd like to focus for a moment on the commentary to Article 5. That commentary identifies as the general concern arising from repeat appointments, possible bias in favor of the nominating party. So that's the general concern, possible bias in favor of the nominating party. And the commentary then refers to a few specific concerns. And a few of those concerns arise from what I see as relationships with particular entities. So there's a concern about arbitrators having a sense of obligation toward a party, or perhaps having financial dependence on a party. But then the commentary also refers to numerous appointments by the same side, whether it be claimants or respondents. And Meg had flagged this issue about concerns about repeat appointments by claimants or respondents. And I think it's important to separate out these different concerns, because for me, some of these concerns raise independence issues, some raise impartiality issues. The independence issues I think of as arising from relationships with particular entities. So when we're focused on relationships, we're thinking about independence. But with respect to appointments by claimants, appointments only by respondents, that to me is a general issue of potential bias, and general issues of potential bias to me are impartiality issues. So I think it's important to separate these out. On impartiality, for policymakers thinking about rulemaking in response to impartiality concerns, the one issue I would flag for now is what I think of as the dual role, dual aspects of numerous appointments. Because if we're concerned about impartiality from claimant appointments or respondent appointments, we can expect there to be many appointments that have given rise to the concern. And I think it's complicated when we look at arbitrators who receive many appointments, because depending on the context, the large number of appointments might be reassuring, or the large number might be concerning. It will depend on the context. And I think a key factor there is balance or imbalance. If there's a reasonable balance between claimant and respondent appointments, then I think the large number should inspire great confidence in an arbitrator. If, however, there is an extreme imbalance, then that may give rise to concerns about potential impartiality. So for policymakers who are inclined to explore rulemaking in this area, for now, I would just flag this issue of the dual nature of numerous appointments. Again, that a large number of appointments might be reassuring or might be concerning depending on the context. I would turn now to independence, and Meg had mentioned this concept of repeat appointments plus, right? That what we see in decision after decision is analysis where the decision maker certainly considers the repeat appointments, but then there are what we can think of as the plus factors, right? And these plus factors range. At times, there might be concern about disclosures or failure to disclose. At times, the focus might be on a relationship between the current case and one of the prior cases. There might be analysis of whether the arbitrator can be seen as beholden to the party who appointed them. So the analysis that we see, again, is repeat appointments plus. And for rulemaking, I think the one issue I would really focus on now, the one rulemaking question, and yes, in yesterday's session on double hatting, Meg had raised this issue of specificity. So I think we have a specificity issue to think about. Would we want to include greater specificity as seen in the IBA guidelines in terms of hard, concrete numbers on the number of appointments? And I think that going the route of specificity, it might have the advantage of providing initial orientation. But I would caution that when we're looking at hard, concrete numbers, invariably the decision maker is going to need to step back from those concrete numbers and look at the big picture. And I think one challenge, my understanding of the draft code, is that the approach is to draft rules rather than guidelines. And so if we want to provide some orientation in terms of a concrete number of appointments, perhaps that kind of guidance could be placed in a commentary rather than in binding rules, because again, I don't think we would want to lock any decision maker into having to apply a rule that mentions a specific number, that you need the discretion to look at the big picture. So on independence, I would just flag this policy choice, whether to go in a direction of greater specificity. And I would just caution again that specificity could be helpful for orientation, but we still need to reserve discretion to look at the overall big picture, the plus factors that I mentioned. And again, I'll have a few thoughts on diversity later in the session.
Thank you very much, Mark. This was really illuminating. You really raised some very important issues on some really of the core principles of the kind of the guiding principles also in investment arbitration. Another core principle of investment arbitration is the freedom of the party to choose their own arbitrators, right? And so how do you challenge, how do you balance these different priorities. And of course, how much, and we said that also at the beginning of the session, how much does it happen, multilateral, repeat appointments and multiple appointments? And so I wonder if John, you can tell us a little more. So who makes the appointment? Is it an issue? How does that regulating multiple appointments that then restrict the freedom of independent and of appointment by the parties? Who's kind of responsible for multiple appointments, and how can we address that issue if we should?
Okay, thank you, Kiara. You put a lot of interesting questions there. The data does seem to show pretty clearly that most investment arbitrators only have one or a small group of cases over a career. On the other hand, there is a fairly small group of individuals who receive a disproportionately large number of repeat appointments. And so what do we make of that? I think as we talk about this problem, as Mark and others have suggested, you need to be clear what it is you're talking about. Are we talking about appointments of particular individuals by a single party? Repeat appointments of particular individuals by one or another of the sides in arbitration, claimants or states? Are we talking about repeat appointments of a particular individual by a particular counsel or law firm? Or are we just talking about the number of appointments in the aggregate that individual arbitrators may have? Now, each of those situations is different, but I think sometimes there's a tendency to elide those distinctions. Let's take the first of those that I listed, the appointment by a single party. Now here, of course, there aren't a lot of repeat players in arbitration. For most claimants, save a few large, perhaps predominantly resource companies, they're not frequent participants. States vary. There are some states for which it's a once-in-a-lifetime mischance. Others that are perhaps more frequent players. So I looked at this to see if there's anything you can tell. In the spirit, I took a quick look at Venezuela, which is, of course, a frequent player. And I used the nifty ICSID database to do this. Those of you who are not familiar with this, you will find that you can search for cases and correlate to arbitrators and counsel and people's favorite football teams and just an extraordinary array of useful data that's readily recoverable. It's a very, very nice tool for research in this area. Subject to checking, it looked to me like there were about 44 cases in which it was transparent from the ICSID website who was on the panel. In those, Venezuela appointed one arbitrator in 6 cases, another in 4, and three other individuals in 3 cases each. Now, by contrast, you can take Spain, which of course is also a frequent player, but which has had a much more diverse approach in the appointments it's made. So I think given the variations amongst individual states, I'm not sure looking at it this way tells you very much that's useful. All right, what about the second situation? Are there patterns of appointments by states and by investors? Now, here, there's certainly a perception in the community. David referred to this, and it does seem to be the case. There is a small group of arbitrators who receive, we'll begin with states. There's a small group that receive appointments almost exclusively from states. The numbers I'm about to give you reflect a sort of quick and dirty plunge through the ICSID database. They're not complete, they need to be checked, perhaps updated post-COVID, but they seem solid enough. I looked at the listed ICSID cases for a small group of arbitrators who are thought by observers, and here, you know, David pointed out that there's this sort of sense among many observers that there are pro-state, or at least frequently appointed by state arbitrators, and then the other variety. But looking at the first group, the ones that are sort of thought to be kind of, in some sense, pro-state, there was one individual who was appointed in 92 cases with no appointments by claimants, another in 26, again with no claimant appointments, another in 24, another in 23, another in 12. In each of these, there was at most one appointment by a claimant. Now, I did a similar non-systematic look at the second group of arbitrators thought to be pro-investor. There was a somewhat different pattern. The top scorer in this group was in the mid-30s, almost all by claimants, but not entirely. Another had 28 appointments by claimants. And after that, the numbers trail off significantly, with a broader range of individuals receiving appointments. Now, there are, of course, other repeat players. There are some individuals who receive multiple appointments, but from both sides. There's also a small and rather elite group of individuals who are frequently designated to preside in multiple cases, and who do that to the exclusion of most other kinds of representations. Now, I don't pretend that these numbers are the last word, but they do suggest to me a couple of things. First, they certainly tend to confirm the notion that there is a group of arbitrators who, at least the people who make appointments, seem to conceive of as being either pro-state or pro-investor. Now, I don't express a judgment here whether that conception is correct, but certainly the people who make appointments seem to think it is, at least has some relevance to their decision. Now, the implications of this under Articles 4 and 5 of the Code, the issues that Meg flagged and Mark developed, are of course under debate and have to be sorted out. However, as Meg indicated, at least so far, the decision makers in challenge cases have not viewed repeat appointments without some undefinable more to be grounds for to uphold challenges. Now, second point, my preliminary dive into the data suggests to me that at least in the aggregate, it is states that are most prone to concentrate their appointments in a small group of arbitrators, and that states do this to a much greater degree than investors. So in response to Chiara's question, who's responsible for repeat appointments? My bottom line would be that at least looking at it in the level I've just been talking about, states versus investors, states in the aggregate tend to be more prone to concentrate their appointments on a relatively small group of arbitrators, many of whom are appointed by states and only by states. Now, what are the implications of this? If Chiara's scheduled for this, I'll try to address some of them in our expected second round of comments.
Many thanks, John. You really gave us a lot of food and data for thought. This is very interesting because on one side we have this requirement and this call for addressing the issue of multiple and repeat appointments, but on the other we also have a lot of players actually using repeat appointments in practice in their cases, and also this disjuncture between maybe sometimes what the criticisms are, but what the decisions and challenges actually say. So really a lot of thoughtful, interesting issues that we should consider. Victoria, I wonder if you can tell us a little more, because when we're thinking about repeat appointment on one side, and we said that one of the possible options is the creation of a permanent court, but on the other side, arbitration is such a different dispute resolution mechanism. And so I wonder if you can tell us a little bit about, when you're thinking about multiple appointments, repeat appointments, and how this issue really goes to the core of arbitration as a dispute resolution mechanism. If you can tell us a little bit about the kind of the adjudicative function and what kind of adjudication system and how far of an adjudicative system do states want, or is the arbitration system ready to include? Thank you.
Thank you so much, Chiara, and thank you to Tom and to the ITA and to all of you for joining us for this really important discussion today. So here's sort of the question that Chiara posed that I will try in my brief few minutes to provide a few answers to think about, or at least some issues to think about when addressing these questions. So state delegates really need to think about how adjudicative of a system do they want. There's a tension here between customizability on the one hand and predictability on the other hand. You can also think of this as a tension between party choice and party trust in the system. Are state delegates looking for a certain level of certainty, or even, shall we say, precedent? Not, that's a word that we don't use very often, but not saying we should create precedent, but are they looking for the level of predictability that might even approximate precedent that we have in a court system? Or do they really want the flexibility and customizability of arbitration? And so here's a couple of issues to think about as we sort of engage with these tensions. So first, with repeat appointments, many ISDS arbitrators might be focusing their efforts on building their business and building their reputation by trying to be appointed specifically by claimants or by respondents, rather than as much developing their competency in general as arbitrators. If we look at the commercial arbitration system, we don't really have a sense that there are, pro-claimant commercial arbitrators or pro-respondent commercial arbitrators, because any party in either of those cases could easily be on the other side, or there may be counterclaims involved in the case, in which the respondent is the claimant on the counterclaim, and so on. Whereas in investment arbitration, even though the arbitrators themselves would say they would likely say this is not what they are doing intentionally, there is sort of a general thought process or knowledge by parties that a certain arbitrator is more likely to be appointed by claimants, and therefore more likely, at least in the party's mind, has some inclination to favor the arguments of claimants, and the same on the respondent side. And so this may lead to the perception that an arbitrator might be in the pocket of investors or in the pocket of respondent states. This is sort of a twist on repeat appointments. The code addresses repeat appointments in the context of the same party or that party's counsel appointing the same arbitrator, but this could also be repeat appointments always by claimants or always by respondents. That's another form of repeat appointment to think about. And what does that mean? If you have an arbitrator that's almost always being appointed by claimants or respondents, is that an indication of that person's mental state or indication of their prejudgment of certain issues? Or is it just an indication of their perception of their reputation within the system, which is also problematic, as was earlier mentioned. Perception is reality in many circumstances. So that's one issue that comes up with respect to repeat appointments that creates a sort of systemic issue. With respect to the code, Article 5(2)(c) says that disclosure in all cases in which the party is sitting as arbitrator, regardless of which side they were appointed by or whether they're the president. I think that's the correct approach that we've got in Article 5(2)(c) with respect to disclosure. But the bigger question, and this is sort of the next tension I want to talk about, is balancing party autonomy and party choice on the one hand with integrity of the system on the other hand. So some in the arbitration community, prominent arbitrators like Jan Paulsen, Albert Jan Vandenberg, Hans Smit, Gus Van Harten, and others have discussed this idea, well, maybe we should do away with party appointment. Maybe we really should just stop this sense that parties get to choose who their arbitrator is just because they're clearly choosing because they think that person is going to decide their case in a way that is beneficial to them, or at least will consider their views very strongly. And so maybe, and this would also solve in some ways the repeat appointment problem, is if the institution appoints everybody. Well, the flip side of that is party choice and party autonomy is one of the main reasons why people want arbitration in the first place. If they wanted to have a situation in which they were just assigned a person to decide their case, then they could just go to a court, and the court would assign them a judge, and that person would hear the case. And so then what would be the difference? Why would arbitration be unique if it was just appointments only by institutions? And why would parties have an incentive to agree to arbitrate if they didn't have that choice? So that's a tension there. You know, on the other side, of course, integrity and belief in the system involves everyone thinking that or believing strongly that the adjudicators are independent and impartial. And this idea that an arbitrator is repeatedly being appointed in certain types of cases or by certain types of parties or by the same party or by the same counsel very much shakes that integrity, that trust in the system. And then, briefly in the couple minutes I have left, I just want to address one more issue, which is this tension between predictability and some form of precedential interpretation of treaty provisions, for example, versus arbitrators having an open mind or being able to change their mind. So one of the factors driving repeat appointments, we believe, is that parties may believe that arbitrators have a certain viewpoint that they've already formed, either regarding how a treaty should be interpreted or how a particular provision should be interpreted, or perhaps whose viewpoint on that particular issue is more persuasive. And so on the one hand, we want arbitrators to have open minds, and we want them to be able to change their minds when presented with persuasive facts and arguments. At the same time, parties are always, when they interview arbitrators and when they're thinking of selecting arbitrators, they're trying to predict what they think the arbitrator might think about their particular issue or problem, or how the arbitrator might interpret a particular treaty provision. And so to some extent, there's a question about what happens if you have the same repeat arbitrator that's being appointed by the party in multiple cases interpreting the same treaty provision, right, over and over. So let's say there's a case 1 and case 2 involving the same treaty, and you have a party that has appointed the same arbitrator as a co-arbitrator in case 1 and also then in case 2. And let's say case 1 comes to an award first, and then when case 2 comes to an award, it appears that the tribunal has changed its view on what that interpretation is of that particular treaty provision. So there's a lot of issues here. You know, was the first award based on the wrong interpretation of the provision? If so, then maybe the second award is correcting that interpretation. Was the second award influenced by outside forces or politics or diplomacy? If so, maybe the first award is the true interpretation. The second award could be the tribunal's response to this backlash from its first interpretation. What about both awards perhaps being valid on their own facts? And if this is really a situation in which arbitrators should be able to change their minds when presented with persuasive evidence, then perhaps two learned tribunals made up of the same or almost the same arbitrators could come to two valid yet opposite conclusions about the interpretation of the same text. And then finally, with respect to this, this question about integrity and trust in the system, is it a problem if Tribunal 1 and Tribunal 2 with the same or almost the same set of arbitrators involved, if they come to different conclusions? Does that mean there's a problem in the system itself? Are treaties vague? and therefore it's difficult for there to be some sort of norm regarding how to interpret them. So these are things that come up when there's repeat appointments, because what's interesting about it is if you have two completely different tribunals and they interpret the provision differently, people are less upset by that. But if you have the same set of arbitrators and they interpret it differently in two cases, people get really uncomfortable with that. And that's something else that's highlighted by the repeat appointments issue. So anyway, the last thing I'll just quickly say is that I think we should focus, and Kara mentioned on the multilateral investment court. That's another option that's looming out there. But it's kind of like using a sledgehammer to crack open the shell of a nut. The question is, do we really want to use such brute force to get all these issues in line, or can we fix the system that we have rather than throw it out? So anyway, thank you so much, and I appreciate the opportunity to speak with you.
Thank you very much indeed, Victoria, for these interesting thoughts. We've been talking for a while about, is there an issue with repeat appointments? And if there, what is the nature of the issue? Is it impartiality? Is it independence? Does it depend on the party? Does it depend on the side? Let us talk about whether we should regulate party conduct with respect to repeat appointments, and what would be the implications of regulating repeat appointments. Before I turn it over to John Crook, let me remind everyone that we do have a Q&A function under Q&A, and that we would very much solicit and welcome your questions for the panel, which we will raise at the end of the program. John, should we regulate repeat appointments in your view? And if we do, does that impact party autonomy?
Thank you, Tom. Let me just confirm with you and Chiara. It looks like we're good on our time schedule. Am I right in that we can take our full generously allocated 5 minutes?
Yes, we are.
All right, good. Does regulating appointments affect party autonomy? Well, I mean, in a superficial sense, yeah, of course it does. I mean, you're sort of, by definition, putting some limitation on who a party can appoint. But let's try to unpack it a bit. If we mean by that somehow putting more teeth or clarity, maybe clarity and teeth, into the requirements of independence and impartiality under Articles 3 and 4 of the Code, I'll leave sort of the metaphysical aspects of that to others, but I'm not sure how to do it or enforce it, at least given the current workings of the challenge system. And that, of course, is the ultimate, as things now stand, the ultimate enforcer of expectations, requirements of independence and impartiality. Now, if we mean heightened disclosure under Article 5.2c, again, who can be against it, but I wonder how much practical difference it's going to make. Article 5.2c says that a potential adjudicator has to disclose all prior appointments in investment cases and maybe commercial arbitrations as well. In terms of disclosing investment cases, I don't know how much this moves the ball, because there is a considerable degree of transparency here already. You can, in the span of roughly a minute and a half, go into the ICSID website. I love this website. And Meg, you guys have got a great tool here. You can go in there, and in about 90 seconds, you can determine what appointments an individual has received in ICSID cases. Maybe 2 minutes if you're slow, but you can do it very quickly. PCA takes a little longer. It may take you an hour, but you can ferret out pretty quickly who's been appointed to what in most PCA cases. Now, there may be some institutions out there that are a little less transparent, but I think with ICSID and PCA and one or two others, with reasonable due diligence and an afternoon's work, you can establish what appointments have been made. So enhanced disclosure on Article 5 may be sort of icing on the cake, but it's really conscientious counsel ought to be investing the couple of hours to look at readily available sources in any event. Now, there could be a good deal more significant impact if one were to take seriously the possibility of filling in that bracket in Article 8 with a number. Now, Meg rightly illuminated the problems with this. All cases are not created equal, or all arbitrators are not created equal. And so it may be difficult to devise a number for X that makes sense given the varieties of cases and human characteristics. But certainly the notion of having an X has a sort of, it does provide clarity, it does provide a touchstone for arbitrators and appointees. But I'm just trying to think through what it would mean in terms of the question that was put to me: what is the impact on party autonomy? Now, let's assume hypothetically that X is 10. And 10 is a nice round number and we're all familiar with it. Let's think about it. Now, my X has never gone above 7, and 7 nearly killed me. But I have an irritating habit of being inefficient, and I also tend to read all the stuff, which means 7 was about the limit of what I could deal with. But there are other people who are more efficient, and all cases are not created equal. But let's assume that there is an X of 10. What would the impact of that be? I suspect that the impact would fall disproportionately on states because, as I suggested earlier, you have got a relatively small group of arbitrators who are carrying a fairly significant volume of appointments by states. One prominent arbitrator in this group currently shows 28 pending cases. Another shows 19, another shows 10. So if X were 10, a number of folks who are now frequently appointed by states might find a significant impact on their ability to accept appointments. Now, arbitrators appointed by investors also would face the same kind of problems, but I think perhaps to a lesser extent because of the lesser degree of concentration. So my hasty dive into the ICSID data suggests to me that a higher X, or indeed an X, whatever it may be, is apt to have a higher impact on the relatively small group of arbitrators who are predominantly or exclusively appointed by states. There are fewer of them, they carry more cases, and so they're going to be impacted more dramatically by X. So X, whatever it may be, is obviously going to impact on party autonomy. It says to investors or states that this person you want to appoint, she's at X, and so you can't offer her another appointment. And that's going to be true on both sides of the line. But as I said, sort of given the apparent concentration of appointments by states and a relatively smaller group of arbitrators who tend to carry more cases, X is probably going to have a higher impact on state autonomy than on the autonomy of investors, simply because you've got each community is drawing on a pool of arbitrators of a different size. I think that's about as far as I can take it. But I go back to my original answer. If you are talking about regulating who can be appointed, by definition, you are going to impact party autonomy.
Thank you very much indeed, John. So, Mark Feldman, the code requires disclosure, and the code is explicit that the disclosure is required so that parties have a full set of information on, among other issues, the issue of repeat appointments. But the code stops here. It does not provide any guidance whatsoever to any of the institutions or the other co-arbitrators who would have to rule on a challenge based, for instance, on the question of excessive repeat appointments. So should the code go further? Should it be bolder, and should it provide some guidance on when a challenge based on excessive repeat appointments might be sustainable or should be sustained?
Thanks, Tom. Well, certainly the broad disclosure, I think, is the right approach. Give the decision maker all of the relevant information. But then, as you mentioned, what standards will the decision maker then apply to those facts? And as I read the code, the standards the decision makers will have right now is independence and partiality. And then within independence, based on the disclosures in Article 5, we have some additional guidance about concepts of loyalty, influence, right? So if you think of the decision maker's toolbox, what they would have under the current draft in their toolbox is the standard of independence, standard of loyalty, standard of influence. But then, as you say, it is a bit of a jump to simply apply those standards to these facts of repeat appointments. As I mentioned earlier, we could think about some additional concrete guidance, but again, I would caution that that concrete guidance should really only be for initial orientation. One thought I would raise for policymakers is, as we're thinking through how ambitious to be with regulation, thinking about independence, thinking about impartiality, I do think that diversity needs to be part of the calculation. And the reason is that the policy choices that policymakers make now will interact with diversity goals. And one requirement for diversity is to introduce new individuals to these cases as arbitrators. Repeat appointments, by definition, will not introduce new individuals. And I thought we had very good discussion yesterday about the interaction between double hatting and diversity goals, and the need to tolerate, to some extent, some amount of double hatting in order to facilitate the entry of these younger individuals into these arbitrator positions. And actually, John Crook has written an important essay in the American Journal of International Law on the relationship between double hatting and diversity, and making this observation that in order to advance diversity, we need to tolerate, to some degree, younger practitioners acquiring experience and then transitioning over. So I think if diversity is part of the equation, as you mentioned, at the same time, we have to think about party autonomy. We must give party autonomy the same weight that we give it to any arbitral appointment. Repeat appointments are merely one form of arbitral appointment, and those same party autonomy concerns apply. I would note with respect to party autonomy that party autonomy is facing a lot of pressure on a number of fronts currently in ongoing Working Group 3 discussions. Obviously, there's consideration of far greater levels of institutionalization. Outside of Working Group 3, there certainly has been discussion of institutions playing a greater role in arbitral appointments. So for party autonomy, we do see on a lot of fronts pressure against it. And so for those who feel strongly about preserving party autonomy, one reasonable position might be to tolerate some limitations on repeat appointments in order to preserve the party autonomy that currently exists under a regime that is still largely ad hoc, that is not dominated by institutions. So I think that could be a strategic choice that stakeholders should consider is it in our interest to give a bit, in a sense, on party autonomy in the repeat appointment context in order to preserve party autonomy really when the party autonomy, the stakes are much higher in terms of institutionalization generally. So I think I would leave with those thoughts that for policymakers thinking about rulemaking, to be sure to think about not only independence, not only impartiality, but to also consider diversity, and at the same time, giving due weight to party autonomy, but also thinking about party autonomy, the pressure that party autonomy is under on a lot of fronts currently. Thanks again.
Thank you very much, Mark. Victoria, it seems to me that in many cases, as John Crook has demonstrated, it is the states that excel in repeat appointments, and they probably excel because there are situations where states face multiple claims. A single investor has a claim, but a state such as Argentina might have 40 claims against it. And there's a certain question of expertise that is associated with repeat appointments. The people who are appointed are truly experts in adjudicating investor state claims and experts in looking at policy making by governments in many cases. So should we regulate repeat appointments? And if we do, would it have an improper implication on the point of expertise?
Thank you so much, Tom. It's a very interesting question that you pose. One of the arguments that's out there is that the pool of qualified arbitrators, and I put qualified in quotation marks here, is small. This idea that, oh, we want to make sure our arbitrator has this expertise that Tom mentioned, and so they need to have, you know, a large number of cases that they've done in the past in order to justify and demonstrate that expertise. And this is one of the arguments as to why certain people are reappointed over and over. But to the point Mark just made, we also need new and junior and diverse arbitrators to develop their expertise. You know, having the same arbitrators appointed over and over again is like filling a cup that's already full to the brim, pouring more water in the cup, while other arbitrators' cups may be empty or dwindling. And, you know, eventually the new and junior arbitrators are going to be, you know, taking up the legacy of the prior arbitrators and having to carry the system forward. So, you know, we really need them to develop their expertise and training, and that is undermined by the repeat appointment phenomenon. There's another sort of aspect of this. There are some nations that have nominated arbitrators to the ICSID roster who are all of a different nationality than their particular state. And you know, this is partially due to biases regarding nationality and lack of diversity and inclusion in the system, but it's also partially due to lagging capacity building in some nations, particularly in the developing world. They don't have the people of their nationality who have the level of expertise that is required. And so perhaps rather than having those nations appoint arbitrators from other parts of the world that have, you know, large amounts of expertise, maybe getting rid of repeat appointments might help developing states begin to better develop their capacity among the arbitrators and even the council within their states. Another point is that new arbitrators, so this cuts against expertise, but new arbitrators may likely have a more open mind because they're not sort of repeat players themselves in the system. They have not become too used to thinking a specific way about certain issues. And so that actually may be good for the system to have a fresh set of eyes. This goes to the point I made earlier about arbitrators appointing, parties appointing arbitrators to the tribunal because they believe those arbitrators have prejudged the issue. If you bring new arbitrators into the system, then that's an arbitrator with a mind that is an unknown quantity. And although parties may think that that is a risk, and that they would be right, there is a risk there in terms of the outcomes. At the same time, that brings integrity to the system, because you really do have a person who hasn't prejudged the issues, who is willing to hear both sides and consider both sides' arguments in a balanced way. Not saying that experienced arbitrators can't do that, but they know that when they're being appointed, parties are expecting them to have already thought about that issue in certain ways. And then another point I wanted to raise with respect to expertise, and this is sort of a point that goes hand in hand, is availability. The most experienced arbitrators, the arbitrators that have the most cases, continue to be the arbitrators that have the most cases, which means they're so busy that the calendar, the timeline gets elongated. And if we believe, and if we just take this as a premise, if we believe that one of the foundational principles of arbitration is speed as well as cost efficiency, okay? If we just take that as a given for just a moment, repeat appointments go against that. You can't be fast if you've got a whole lot of cases. And having a whole lot of cases and slowing down the system is not very cost effective. And parties have already said they're dissatisfied with how long arbitration is taking. There's been so many surveys that have been done around the world about party satisfaction with arbitration, and almost all of them universally wish it would take less time, right? So one of the advantages of getting rid of repeat appointments is that newer arbitrators may have more availability, and therefore they can complete the cases more quickly. John mentioned that every arbitrator has an upper limit on the number of cases that they can competently and confidently take on without compromising quality, which is their X, as John puts it. But some arbitrators ignore their X and take on as many cases as possible and push them off to some distant date. Should the code state a specific number, or state that an arbitrator must disclose their X, or how many cases in which they are currently sitting as part of the standard disclosures? Right now we have Article 5.2c that requires all cases to be disclosed, and a party could extrapolate from that information how many cases the arbitrator has. And maybe this is just something parties need to decide. What is their tolerance for delay, or what is their tolerance for how busy an arbitrator is? So that's on the one hand. On the other hand, maybe it's something the system should decide in pursuit of diversity, equity, and inclusion goals, as well as in pursuit of making sure the system is efficient, effective, and doesn't needlessly increase costs. So those are my thoughts. Thank you.
Thank you very much, Victoria. Meg, we discussed that the code addresses the issue of repeat appointments in part because it requires very broad disclosure of all prior cases, all prior appointments in Article 5.2c. We've also discussed that when challenges have been made in the past, these challenges almost always fail when there are challenges on the basis of repeat appointments. And so I'm wondering if we're raising the issue of repeat appointments, we're obligating arbitrators to disclose, we're perhaps suggesting to the parties that they might want to bring challenges on this basis, but then we're providing zero guidance to fellow co-arbitrators in the ICSID system or the institutions and other systems as to when these challenges should be sustained. Is there a risk that they will continue to be denied? And so we've created a code that creates a certain expectation, but is actually going to be viewed as ineffective in actually doing anything about the repeat appointment issue. Let us be bold. Should we be bolder and simply say repeat appointments are a problem? Let's set an X and say, that if there are more than, let's pick a number, 5 appointments over 5 years by a party or council, those will be viewed as perhaps being eligible to have the challenge sustained. What about that sort of an approach? Would that make any sense?
It might, and certainly that's a question delegates are going to have to look at. What I tend to think is more important here is that we continue to drill down and get more specificity on what is and isn't on the right side of the line so that you have better predictability and so you don't get into more challenges. I think that's probably where we ought to go. And in many ways, it goes to one of the questions that's been raised here, which is the question of transparency of decisions. And I want to say ICSID certainly publishes, and on the web that John has been talking about, we publish and we have a very good chart, in fact, of all the challenge decisions where there's been consent. There has been consent in the majority of them, but our new rule amendment would make all of those decisions published. And I know a number of other institutions have been requiring challenge decisions to be published so that there is that kind of predictability. So it will be for delegates to decide whether an absolute number is bold and worth the downsides. But I think also you need more understanding of what is and isn't on either side of the line.
Thank you, Meg. David Probst, any reflections from the discussion you've heard today? And in addition, how do you view the path forward for the draft code? What can you share with us? We know that comments by the member states are still outstanding and they will not be received until later this fall.
Thank you very much, Tom. Indeed, perhaps the first comment, this was a very interesting discussion and debate for me, as I think that many comments touched upon exactly the issues raised by the working group. So I think we will be looking closely at this discussion and your input when we are continuing working on the draft. And then also very much looking forward to receive comments, in particular also by state representatives, and the notice that the deadline for submitting comments on the draft code of conduct, either to the ICSID Secretariat or the UNCITRAL Secretariat, was extended to 15th November. So there's still time, and we're very much looking forward to get more input, and then we're looking forward to continue working with Meg on the revised draft under consideration of the comments that we received, which will then hopefully soon be discussed in the working group.
Thank you very much, David. Let's open up to questions. So I encourage the audience to send us any questions they might want to have. So let me throw it open to our faculty. There's a second question out there, a question of availability and an absolute potential bar on the number of cases that an adjudicator can sit in at any particular time. Some people have said, if you set it too high, if you set it at, call it 25, it becomes meaningless. If you set it too low, it becomes incredibly burdensome and perhaps irrational. So is there a point in setting a number at all if one is not appropriate and nor is the other? Would anyone like to comment on that?
What I have heard from the faculty, and I think might be a very interesting way to proceed, is to include guidelines in the commentary. I think the commentary can be very helpful, and just say, you know, these are the different number, instead of having a number, because I think John raised an excellent point saying, well, the X is different depending on arbitrators, and others have said the issues is what is the arbitration's function? Is it a precedent, or is the wing, or is it where in the procedure the case lay? And I think giving guidance in the commentary might be a helpful way forward. I don't know what others think.
I had another thought as Chiara was speaking, and something that she said actually triggered something in my thought, which is John said that X is different for every arbitrator, and Chiara said that can be challenging if we're going to put X in the code. But what if we put a percentage? What if it was whatever your X is, if you have, if you're more than 80% capacity, maybe if we use that, that might be a way in which you could capture the spirit of what we're trying to do without necessarily giving a rigid number.
Let me plunge in here a bit in response to what Chiara and Victoria have just said. Certainly the commentary might, if we're headed on the road toward X, the commentary could certainly make the point that, as Meg suggested, there is an enormous difference in the relative workload depending on whether you are presiding or wing. Presiding arbitrators tend to have to do a whole lot more work, invest a lot more time. And so it may be, it's appropriate to reflect that. The relevance of that to the discussion we're having here may not be too great because, of course, you have a somewhat lower incidence of parties who are arbitrators who are conspicuously identified with one side or another being presiding. But in any case, I think it would certainly be appropriate to add a sentence or two that makes the point that all arbitrators' roles are not created equal, and that in assessing, in defining whatever X may be, you have to somehow take account of the fact that the burden may vary greatly depending on the role that an arbitrator plays in a particular case.
And I would just add, for these policy decisions, I think it would be helpful to have as much data as possible. In particular, the amount of time start to finish for investment arbitrations. What trends do we see with the amount of time that it's taking? And so I think for policymakers, just to provide them that kind of data.
Last question. I think this is particularly interesting to me. In these situations with many claims against a certain sovereign, is there a point where an arbitrator has already ruled on a government measure, whether it violates FET or whether it's expropriatory, where a subsequent repeat appointment of that arbitrator would become truly problematic? Because not only is it a repeat appointment issue, but it becomes an impartiality issue. Any thoughts whether that type of a repeat appointment ought to be regulated? Maybe Mark, if you could start us off.
Sure. Well, the Caratube case comes to mind. So in Caratube, you had a challenge, and there was an independence aspect and an impartiality aspect. And ultimately, the independence aspect, based on prior repeat appointments, that did not carry the day in terms of the challenge. But the impartiality aspect did carry the day. The fact that one of those prior cases was closely related to the current case, which is similar to the situation that you're describing. And I think goes back to Meg's point about repeat appointments plus, that we see these plus factors. And in Caratube, the relationship between the two cases was a very important plus factor.
If I may add, I completely agree with Mark. He's just saying that the issue there might be the X and not the repeat appointments as such. So that the issue is the issue conflict and is not the fact that the number was higher. And I think the tribunals deciding challenges have consistently said this is what matters, is not how many cases, but what kind of cases and what how proximate the cases are.
Thank you, Chiara. I think we are out of time. And so I wanted to thank our distinguished panel very much for their incisive commentary today. I hope that this is going to be of benefit to everyone drafting their comments for the November deadline. And I want to invite everyone to our last, but perhaps most important program, because it will address how do we implement the code, how do we make it enforceable. Those are very interesting, very challenging questions. The program will be tomorrow at the same time at 9 o'clock Eastern. And so thank you all very much. Thank you to the audience for participating. And until then.